Hello, good morning, ma'am. And Mr. Fuller, we have you both. Excellent. All right, and we're ready to proceed with the case. Mr. Fuller, you are the appellant. You could reserve up to 5 minutes for rebuttal. What is your pleasure, sir?
All right, I'm watching. My screen's up.
Oh,
That wasn't me, Judge.
no, I understand, but I want to make sure. Okay. All right, Mr. Fuller, let's go ahead and proceed then.
Thank you. May it please the court. And the plaintiff would like to reserve 5 minutes.
5 minutes? Very good, sir.
I want to start off by thanking the court first for doing this new and trying time. Our practice has changed, and I'm glad that DCA is keeping it in the forefront. This case involving Ms. Quinn and the issue before the court, from our perspective, focuses on the delegation clause in the arbitration agreement. Delegation clause requires all and any issues and controversies arising out of the arbitration agreement, which was included in the admission agreement to the nursing home, to be sent to the arbiter for decision. Now, I think the rub in the case is that the plaintiff complied by the terms of the arbitration agreement for the selection of the arbiter.
Yep, Mr. Fuller, I've got a question on that. Okay, so in looking at the language of the arbitration agreement and the methodology on how the arbitrators were to be chosen,
Yes, Your Honor.
it's your position here that your client selected the arbitrator, right? Mr. I think it's Wardell,
Sure.
excuse me. And so I guess the question that I have is I'm looking at the methodology, and are you saying that your client selected the sole arbitrator that is going to try the case, or are you saying that your client selected the arbitrator that would then pick the ultimate sole arbitrator? Because if I read the language of the agreement, I'm not going to read the whole thing, but in the middle of it, it says if the parties cannot reach an agreement on an arbitrator within the 20 days of receipt of the demand for arbitration, then each party will select an arbitrator. You're saying you selected. Then the clause goes on to say that these arbitrators will act only for the purpose of appointing a sole arbitrator to hear the case subject to the criteria above. If either party fails to select the arbitrator, and then it goes on to say they forfeit the right to choose an arbitrator. So I guess the point I'm trying to make is, as I read this, then Mr. Wardell then is the one to pick the sole arbitrator who will then try the case. And I'm not sure if I understood where your position was in your brief.
So, Your Honor, that's a great question. And we read that clause as exclusionary. If the other side does not pick or make a selection, there's no reason to pick a third arbitrator, right? Because they didn't enact that
Well, the only way that I can reconcile those provisions is that they effectively forfeit their right to choose an arbitrator. And so, you know, I don't know. I mean, I think the argument could be made either way. And the only reason I bring this up is because if I'm understanding your argument, that the trial court, because the language of the arbitration agreement provides the methodology, and that your client exercised its, right to select, that the trial court intervened and didn't have jurisdiction to intervene when it did, when the motion to compel was filed. Am I understanding that correctly?
That's correct, Your Honor.
Okay. And so I guess at the point when the motion to compel was filed, then could the court, if let's say you read it perhaps the other way that I read the agreement, that your arbitrator that you selected has to choose the ultimate arbitrator. because the other side forfeited their right to choose.
Yes, Your Honor.
So let's say you read it that way. Could the court, under the provisional statute, go in and provide a provisional remedy that says, okay, Mr. Wardell, you haven't selected the ultimate arbitrator, you need to select? Would that be, I'm trying to understand whether or not that's something you would agree that the trial court could step in and do.
I think not. And if I might, I'll explain why.
The court couldn't even do that. Okay, explain why.
Because if we go in the most recent case issued by Justice Kavanaugh, so that we have to give effect to the agreements that are entered into by the parties. And if you look at the first paragraph under the arbitration section, it says that any issues with the interpretation of the arbitration agreement go to the arbiter. So
okay,
that would
but let's go back now. Remember, it's my scenario, not your scenario, right?
Yep.
So if it's my scenario, then the ultimate arbitrator has not been picked or has not been appointed. So we're still within the choosing of the arbitrator, right? So I guess then I ask the question again. So since the ultimate arbitrator has not been chosen, then would the trial court be able to intervene and provide a provisional remedy, such as ordering that arbitrator to pick the ultimate arbitrator?
I still believe that would be a decision for Mr. Wardell.
But then that makes the statute just useless, right? I mean, because
which statute, Your Honor?
the provisional, to be able to come in, excuse me, my notes, to be able to come in, provisional remedies, 682-031.
No,
Because
I'm sorry.
okay, so I'm trying to think of a situation in which that statute would then apply based upon your argument.
Well, if there had been no selection by either party, then yes, then that statute would apply. The court could then intervene. But because we had made our selection pursuant to the agreement, then all these issues go to Mr. Wardell.
And
now,
actually, though, what appears to have happened here is you both had a set of requirements and you went one step further than the other party, but actually neither of you fully complied with what the arbitration agreement required, correct? Because you didn't go the next step and saying, okay, this is our, you didn't pick your person so that they could together pick a third person. So Mr. Wardell is picking this person and we consider that to be the arbitrator for this case. Isn't that what should have happened under the agreement?
and let me make sure I'm understanding the question. Your question is that pursuant to the agreement, Mr. Wardell had to go a further step. And that's
correct,
why
because he's not the arbitrator. He's the person you picked to pick the arbitrator. But
well,
you're referring that I was a little confused by your brief too, but if in fact you had said, okay, we're going to use him as the arbitrator, that'd be another issue we might be dealing with, but that's not what the agreement called for. It called for two people to come together and to pick an arbitrator. So since that didn't happen, why wouldn't a trial judge be able to step in and basically give the same opportunity again? That it's the same pattern. He allowed both of you the opportunity to pick an arbitrator, and that's when you all chose not to participate.
So again, if I'm understanding your question, the way we interpret the arbitration clause is it doesn't require Mr. Wardell to pick a ultimate arbiter. By our selection of Mr. Wardell, and the lack of selection of anyone at that point in time as an individual arbiter, they waive that right.
But Mr. Fuller, so let me, I just got to go back to the language, okay? So it says they effectively forfeit their right to choose an arbitrator. That they is referring to the party. The only thing the party can choose is this arbitrator who will then select I'm calling it the ultimate arbitrator because I can't think of any other better word for it.
Fair enough.
But so, you know, I guess my point is, I think you're still within the method of the selection of the arbitrator. Now, do I agree with you that the other side did not select their arbitrator? Yes, and I think they've basically conceded based on the timelines that they didn't say, okay, I select this one. But then we have a different issue is that they actually selected 3. So, you know, could they then say, well, one of those, they may very well be. So, I mean, I can see the point of the trial court here on a gotcha scenario, because had the other side just, instead of saying selecting 3, had just given you 1, they would have picked their 1, right?
That's correct. That's what
So that, I think that's where the trial court is coming from, is that, okay, so they selected 3, you didn't like their 3, and then in the end, you know, on the eve of the last, before the 21st day, you said, well, we select this one. So, you know, looking at how that came down, the other side really had their selection. So maybe the court at that point should have said, just pick one of the 3 that you selected.
the court could have issued that ruling.
And would you have it, would the court have been within its jurisdiction to do that?
No, I do not believe so.
Okay. So I'm trying to think of, can you fashion me a scenario where the trial court could have, like, what kind of provisional remedy does the statute contemplate then?
Sure. Had neither side picked an arbiter, then yes, then the trial court could come in and make some sort of ruling or selection in that sense. I think the provisional remedy is intended for a very, very limited purpose, not where one party is complying with the agreement and the other isn't. Now,
and Mr. Fuller, can I intervene, because I'm looking at this case, and I think what the trial court here did basically took the position that you cannot select an arbitrator on the last day, and that's why she felt to intervene to fashion her own remedy. So I like to always go back to what is appropriate. Look at the agreement between the parties. There's forfeiture language in there, and the forfeiture language is part of the agreement that the both parties reached. And so I think in this case, I don't believe the trial court ever considered the question of whether the estate picked the arbitrator of the chooser. I think in this case, though, the trial court got upset with the fact that you can't select an arbitrator on the last day, which, I mean, regretfully, you know, this is what she made her decision. So the issue for us now is that we're dealing with one party who selected 1, Mr. Wardell. We have now another party that, under the terms of the agreement, it said to select 1. They brought in 3. So, and in essence, the forfeiture clause picks in. So we have one party that's not part of this process. So the question becomes right now, what is the appropriate remedy? The judge's remedy under the provisional perhaps went beyond what the statute contemplates. So it's up here on cert. So what do we do? There, you know, we have to, as you know, well, did the court make a mistake? Or I'm paraphrasing, you know, that. Sure. And secondly, where's the irreparable harm? And so I want you to, in the brief time that we have left, is that let's just assume the trial court was wrong in fashioning this remedy. She's trying to accommodate, but regretfully perhaps went off the, you know, did not do it in compliance with the statute. So if that is a mistake, where is the irreparable harm? Can you bring this issue up on appeal?
Yes, I believe we can. So, and in a roundabout way, Chief Judge, I think I'll answer your question. The issue here is giving both the Federal Arbitration Act, which both sides agree apply, as well as the agreement between the parties, a textualist read. Okay, sort of what Kavanaugh did in the case is escaping me, Henry Schein case that was issued in 2019. We have to give meaning to the terms. And I think you're right. I think the lower court judge felt that it was unfair picking the arbiter on the very last day. But that's the way the agreement reads. I don't think it's appropriate for the court to create an exception to the contract between the parties for being unfair. I think the court has to apply the agreement as interpreted, and using the delegation doctrine should send, and again, the irreparable harm is the court has now changed the terms of the contract that my client entered related to her mother's stay at the nursing home. That's the irreparable harm. My client doesn't get the benefit of the bargain of the contract she entered.
And then the question becomes, by virtue of the trial court's present order, you're left in a position that you don't get to choose your arbiter of choice. And so can that be remedied on appeal? Because you know, in irreparable harm, and you know that there's a statute that says that if an arbitration, for you to appeal an arbitration, it's very limited to certain criteria, that if an arbitrator, you know, acted fraudulently and so forth. So the fact that you don't get to choose your own arbitrator, is that by itself, can that be appealed in the future? And if it can, then maybe it would undermine your irreparable harm argument. But if you cannot, then perhaps that would be your irreparable harm. That's what I'm just trying to find out.
Correct. The answer is, I think the court exceeded its authority by entertaining any jurisdiction over this case at this point because of the delegation clause. And I know I keep going back to that, but Justice Kavanaugh made it very clear in a similar argument, Chief Judge, which you're relating to, was made in that case of Henry Schein. And the defendants argued that, look, it just makes sense. It's simplistic, it's easy. Justice Kavanaugh said, well, that's not the way the statute was written or the contract between the party was written. And again, I think that the issue of interpretation as to whether Mr. Wardell has to pick a third or he himself is the sole arbiter has to be an issue taken to him. And then under Section 10 of the Federal Arbitration Act, if he exceeded some sort of authority or power in making that, that could be remedied on the backside.
And
Now-
I
now, Ms.
apologize, Mr. Fuller, because you're about to get into your rebuttal. I just looked at the clock and I think I'll let you go into your rebuttal time. But Judge Smith, you had a question?
Yeah, I do. Yes, I do. Okay. So I know you keep going to the delegation clause. I'm going to bring you back to the arbitration agreement, the section we were talking about, the methodology.
Yes,
So
Your Honor.
in my scenario, again, with where Mr. Wardell has to pick the ultimate arbitrator. Okay. So I'm looking at the agreement. So if that is the situation as I'm reading this, then he can only act because this is what the parties agreed to. These arbitrators will act only for the purpose of appointing a sole arbitrator to hear the case subject to the criteria above, which talked about their qualifications. So I don't see how we jump to, now that he was chosen as that party's selection, how we can jump into an arbitration proceeding where that arbitrator only has the ability to pick the sole arbitrator. So his hands are tied by the actual terms of the party's agreement. So I don't see how we even get to the delegation clause, because I don't see how that would be resolved because we don't have an arbitrator.
And in that scenario, Your Honor, you could send this case back for Mr. Wardell to select the sole arbiter. Now, I, to some degree, with all due respect, disagree with you on that interpretation.
I understand.
And Mr. Wardell could entertain that issue because that's what the delegation clause requires. And the court has been clear repeatedly, both at the US Supreme Court as well as the Florida Supreme Court, if there is a delegation clause and it's clear and unambiguous, which if you go back to the defendant's initial brief in this case at the trial court level, they raised all sorts of cane about there being a delegation clause, that all decisions have to go to the arbiter. I understand, judges, you may not agree that Mr. Wardell has that ability to make that decision. But again, that would fall under Section 10 of the FAA, just like Justice Kavanaugh described in the Harry Schein decision. It's not for us. I'm sorry.
No, Mr. Fulkus, I wanted to make sure that you answered Judge Smith's question because you really have gotten into your rebuttal. So I want to give Ms. Day an opportunity to proceed. All right. So I will give you just a couple of minutes on rebuttal to wrap it up, sir. Okay.
Thank you, Judge.
Wonderful. Thank you. I will stop the clock right now. And Ms. Day, if you could unmute yourself, ma'am, we're ready to proceed with your argument.
Thank you, Your Honor.
And can I just start with the question, because it's a very interesting, the series of questions we asked Mr. Fuller, but I'll tell you what I'm concerned with, Ms. Day, and help me out. In fact, if I could figure out this clock, bear with me. It's acting up. There we go. Okay, here's what my concern is. I'm looking at the trial court's ruling, and I really think that the court got concerned or upset that the fact that the selection was made on the very last day. Well, the agreement calls for that. So, and what the court was trying to do is to fashion a remedy that regretfully was not within the confines of this. So my question to you is as follows. We have Mr. Wardell. He was the one that was selected by the estate. And then if you look at the contract, Mr. Wardell was supposed to choose an arbiter, as well as your client was supposed to select one who will ultimately choose an arbiter. So that has not been done yet. And so I'm troubled with the fact that in my mind, okay, what the judge did regretfully was beyond what she was supposed to do. So if you assume that is error, then the question for me is that irreparable harm for purposes of cert? And looking at that, is there irreparable harm? And in asking Mr. Fuller, and you're looking as to what would be the harm, well, can this, you're not having your own selector of an arbiter for a future, if let's just say this case goes through with what Judge Mascarell has indicated with the arbitrator that was selected, goes to a full trial, and then whatever award or not award, can he at that point make an appeal saying, wait a minute, we were never allowed to choose our own arbitrator? If you look at the statute, it doesn't give them that opportunity. So I guess an argument could be made, it would be irreparable harm. So these are the two things that I'm looking at. Help me out with that. And I apologize, it's a loaded question, but I think it's really key in this.
Well, Your Honor, to answer that question, it pretty much encompasses my whole argument because you address all three elements that are required for certiorari jurisdiction. First of all, whether there's irreparable harm, which includes two elements, which is one, material injury, and then secondly, whether it can be fixed on appeal. And then the second question is, if those elements exist and there is jurisdiction, then we get to, okay, so if the trial court erred, and I don't believe it did, but I'm going to accept your hypothesis that the trial court did err, then was that a departure from the essential requirements of the law? And I have answers to all of those things, but it might take me a little bit to untangle. So I'm trying to figure out where to start. I'll start, maybe the easiest thing is the departure from the essential requirements of the law. Of course, that's what you get to second on the jurisdiction analysis. So you have to find jurisdiction first. I'll discuss that and about the appeal. But as far as even if the trial court did err, there just was not a departure from the essential requirements of the law, because the essential requirements of the law isn't just whether there's mere error. This court in Fassy has said that, and it's said it multiple times in other cases. It's not just a disagreement with the court's decision. There must be a violation that's a clearly established principle of law that results in a miscarriage of justice. So as we know, statutes can provide that essential requirements of the law, and the trial court acted within its authority given by the Florida Arbitration Code, the statute 682.031 that provided the authority to create this provisional remedy. So
let me ask you a question along those lines. As you know, the arbitration code is very specific. And part of that is that where I'm concerned with, you are based on your argument, you're basically taking away a party's right to choose their own arbitrator. So if you're saying if the parties will agree to arbitration, and that agreement says I get to select the arbitrator of my choosing, and the parties will agree to that, that's part of the agreement. Why is that not a departure from the essential if you are taking away a party's right to choose their arbitrator in a required, when it's a binding arbitration? We're not talking about non-binding, we're talking about a binding arbitration. Why isn't that error?
Your Honor, the trial court didn't take away the party's right to choose their arbitrator. The parties had agreed that either they agree on an arbitrator together, or they separately agree on their arbitrators. And Judge Smith was dealing with the terminology. It is confusing, but we chose the word nominator. These two arbitrators would be nominators who would come together and then agree on the arbitration. And that's what the parties already agreed with. The trial court—
But doesn't the order then go one step further, which is where, tell me why it wouldn't be irreparable harm if Mr. Fuller's client then chose not to participate. So therefore, instead of using your nominator, the judge just picks.
Oh, well, that wouldn't be, again, that wouldn't be irreparable harm. Again, we're more, in my mind, and it does get convoluted, maybe whether it's irreparable harm or whether it's a departure from the essential requirements of the law. But the Florida Arbitration Code also gave the trial court the authority to just pick under section 682.04. And we included that in our motion, although the trial court ultimately really, it just ordered the parties to do what they agreed to do, which was the 20 days have passed, both select their arbitrators who will come together and select their final arbitrator. And because there is no case law that gave the trial court direction on how to use section 682.031, the provisional remedies, there's really no case law that discusses whether a trial court can correctly or not correctly use the arbitration selection provision of 0.04 in 682.
But 04, if I look at 04, it talks about unless the method fails. Okay, so
Correct.
Looking at what was done, okay, the parties, because the agreement specifically said, well, you know, if they can't reach an agreement within the 20, then each party will select. And while your client selected 3 nominators, as you've called them, that really didn't fit within the confines of the agreement. Now, the other side did select just 1. So if I look at the terms of the agreement, one could argue, as Mr. Fuller is arguing, that the method didn't fail. The methodology was followed, and your client did not select on the 20th day you know, the one person who would then nominate the ultimate arbitrator. So I don't see how 04, because it requires, if the parties to an agreement to arbitrate agree on the method for appointing arbitrators, this method must be followed unless the method fails. So I see that the method was exercised as opposed to failed. The only thing that failed in the end is, you know, a somewhat, you know, I guess what the trial judge called a gotcha move, you know, at the very last minute, saying, well, I select this one. Now, ultimately, I guess Mr. Wardell could select himself. There's nothing I see prohibiting that. But anyway, I don't see how 04 applies. I guess that's really my question, and maybe you can help me with that.
Quite honestly, Your Honor, Florida doesn't apply because the trial court did not select an arbitrator for the parties. I think it could apply. Our position is that the method failed because once we had this gotcha named person by opposing party, we spent 7 months trying to communicate with them about going forward with arbitration in any way, trying to clarify their selection. For 7 whole months, we received no responses until on the day before the motion to compel arbitration was.
But if I may, Ms. Dede, I mean, you keep saying it's a gotcha. What they did was well within the right. And the fact that your client regrettably, and it goes back to the agreement, and it goes back to what the arbitration code, and if it says this is what we've agreed to do. And I know that the judge said a gotcha. Well, it was within their right to do that. And if your client would have selected just one person within the time period, then these things could have been done. And I guess I share what Judge Smith has indicated with the trouble that I have in my mind. I'm thinking the methodology was followed. You may not be happy with the manner in which it did, but the methodology was in fact followed within the time period contemplated by the parties and the contract of the party. So whatever happened afterwards, I see that as irrelevant. And I know your client for 7 months was trying to work it out, and I appreciate all that, but it goes back to the very initial thing is to, was it, and it goes within the cert standard, was it error what the judge did? The judge intervened in an area that perhaps she shouldn't have intervened because the methodology was followed. Maybe in this case, what needs to be done is that we have Mr. Wardell, and he now has to go one step further to select an arbitrator, but there, at least in my mind, based on what's before me, your client regrettably forfeited the right to participate in the selection. So help me out, and all the things that happen afterwards, I don't believe that's relevant to our issue before us. So help me out with this.
Your Honor, the trial court made no decision that there was forfeiture. It didn't make any decision on the facts or even on the agreement at all. It just simply went straight to it, the statutory authority it had. Again, this court in Stilson has said when there is no case law precedent, when there is authority for the court to do it, there is not a departure from the essential requirements of the law. And this court further said that this court should not find a departure from the essential requirements of law just to create that precedent. And as I said, there is no case law really discussing these statutes yet. I think that there would be, but at this point, I just do not feel like, even if you feel like this is error, that this could be considered a departure to the extent that on certiorari review, without precedent guiding the court did what it felt like it had to do to get the arbitration going. I would like to address quickly your concern about the appeal and about irreparable harm, that really the jurisdictional side, because let me just say that because there was no departure from the essential requirements of the law, the cert petition should be denied. But if there's no jurisdiction, the cert petition should be dismissed at the outset. I know you're concerned, Chief Judge, about whether or not there's a right to appeal this. Well, the irreparable harm has two elements, as you know. First, there has to be a material injury. And despite whether or not there's a right to appeal, the plaintiff has not shown a material injury. He himself quoted cases that said that time and cost of litigating.
It's not time and cost. My main focus is the selection of your own arbitrator. That's what I'm focused with, that here's someone that you want. And this is something that the contract contemplated. And now you don't have that arbitrator. And so it goes into a full arbitration with somebody that they did not choose. And that other arbitrator or whatever comes back with a verdict that's contrary to maybe their position. And if you look at the exception in the statutes to what could be appealed at that point, the selection of arbitrator is not one of those enumerated. And it's very specific. It has to apply to only these 5 exceptions. So that's what I'm zeroing in, not the cost, not the thing, the fact of selecting my own arbitrator that I've agreed to with the other side.
I thank you for that clarification.
All right.
I understand, Your Honor. That would go to the estate's claim that they were violated of a statutory right. And I agree that if a statutory right, like in the pre-suit med mal cases that plaintiff cited in their brief, if those statutory rights are trampled over or not upheld, then that does become a material injury worthy of cert jurisdiction. However, the FAA and the Florida Arbitration Code does not confer a right. The only right they allow is an order to arbitrate. Well, we've already stipulated and got that order. It doesn't confer a right to comply with every single term of the agreement. And I am not suggesting that not complying with the terms of the agreement is the way the court should go at all. But even under the FAA, if agreement terms can be modified. If they're unconscionable, they won't be enforced. They can be severed if they violate public policy, and arbitration still goes forward. As to choosing an arbitrator, both the FAA and the FAC expressly make an exception that says the trial court can step in if those terms fail under the FAA, which is what our contract is expressly governed by. If there's a lapse in the appointment for any reason, and our point is that a 7-month. Okay, so they say that they named the arbitrator, and they did name Mr. Wardell. It was January 7th before we came back and named a single arbitrator, Mr. Stouffer. But we could not get any communication. We could not get any responses. We could not get any lapse in the arbitration.
But if I may, Ms. Day, you had that opportunity within the time period contemplated in the agreement. Whatever happened after the fact is, regretfully, it is what it is. But the fact of the matter is, and it goes back to what the FAA contemplates, that's if the methodology goes wrong, if the parties, if both sides mess it up. Here, it was well within their right to select whoever within the time period. And it was appropriate within the time period. If it's the last day, it's still appropriate within the time period. Whether this is a gotcha or not, it's not a gotcha. It's well within the time period. Where the problem is that your client, instead of complying with the agreement, chose to pick 3. I wish they would have just picked 1. If they would have picked 1, all this would have been rendered moot, but they did not comply with the agreement and instead selected 3. And instead of at that point, maybe having communication with the other side, hey, I know we got 3, but maybe you could pick 1, keeping in mind that, hey, we have that deadline, within the time period, it wasn't done. And so when the time period came and went, all of the efforts that your client did after the fact, it doesn't matter. And so for me, that's not where the methodology failed. And here, at least in my mind, we have to look at the contract, and this is what I'm struggling with. And you're absolutely correct with the case law says what it is, but that's if there's a breakdown. There was no breakdown here. We have one party that complied and one party that regretfully did not. That's where my problem is.
Respectfully, Your Honor, there was a breakdown. If there had not been a breakdown, we would have had retention letters from Mr. Wardell. It would not have been 7 months of silence with still no arbitration proceeding. And the only communication we got was when, again, we had that motion to compel in May of 2020, after supposedly an arbitrator was selected in September of 2019. There was a breakdown. And I would like really quickly, I know my time is running, to briefly just talk about the appeal, the problem with the appeal. Agreed, there is a limited availability of appeal in arbitrations. I don't believe that's a reason. I don't think this court has any authority to expand certiorari because there is no appeal. And that goes back to my argument that there was no material injury because the deprivation of a contract term is not the same as the deprivation of a statutory right. But even as such, when the legislature revised the Florida Arbitration Code in 2013, it added this provisional remedy section. It's a brand new section in the revised code. It also expanded the number of appealable orders in section 0.20 that talked about what you can appeal from arbitration. But all at the same time it did that, it did not include appeals from these provisional remedies in that. So if the legislator wanted to expand the rights to appeal, it could have done so. It knew how to do so, and it did not do so in the revised code. It provided really a broad range. Any urgent matter, any matter needed to keep the arbitration going could come up under these provisional remedy statute. And if the court varies from Florida precedent that limits the scope of certiorari, this could become a means of expanding certiorari review under this statute for almost any kind of reason that a plaintiff might or a party might want to come before this court. My concern is that in this case, this is not the case, because the material injury doesn't reach a level of statutory, because the departure of from the essential requirements of the law did not go to the point of, it didn't disfollow precedent. It just had no precedent to follow in the first place. This is not the case to expand certiorari review. And for those reasons, unless your honors have any other questions, we would ask you to dismiss for lack of jurisdiction, but if not, at least deny because there was no departure from the essential requirements of the law.
And I appreciate, Ms. Dede, I peppered you a lot, so I appreciate your presentation. All right, any questions from Judge Smith or Judge Stargill? Very good, thank you, ma'am. Now, Mr. Fuller, you did exhaust your entire rebuttal, so I'll give you just a few seconds if you wish to wrap it all up, sir, okay?
Fair enough, Judge. Thank you, Chief Judge. And I would say, in keeping with the Chief Judge's requirements and keeping it short, that if this court was to interpret the arbitration provisions as Judge Smith has suggested, that neither of the parties had, and nor had that issue raised at trial court, but that Mr. Wardell then be given the opportunity to select the, as we termed here, the ultimate arbiter. And with that, I will turn it back over to the court.
All right, well, thank you both. Really, it's a very interesting issue and well argued on both sides. Thank you both. All right, I'm gonna trouble you and ask you to please